Welcome to another renewed webinar of great importance to a wide audience, this one having to do with privacy matters. This is an update from a year ago, almost to the, well, if not the day, certainly perhaps the week and the month when Steve gave us a rundown on privacy matters in 2023. A lot has happened since. And we're very, very fortunate to have Steve here with us to catch us up on that. I say very fortunate because, ladies and gentlemen, if you saw the day in New York and Rhode Island, you would consider yourselves lucky to have us, and that we're not out there playing hooky, because Steve and I like to play hooky on sunny days, and that's what we definitely have, a beautiful day in May. We'll put that aside and get into the issues here. Steve, as I say, there's been a lot that's gone on in the last year, and we'll go through the kind of step by step. But let's begin with if those in the UK will forgive us for dealing first with the US states. You have 50 states, potentially with 50 different aspects of privacy matters. What's happened in the last year, either to make that more fractured or bringing it closer together? Are there any trends that you can kind of point to that would make it practical for us to pay attention?
Yes, I mean, I would say somewhat contradictorily that the system that we have in the United States, with no federal comprehensive privacy law, we've got a hodgepodge of state laws that have different thresholds for application. We have a handful of federal laws that deal with privacy with specific sectors or particular individuals, such as minors. So it is fractured in a sense, but it is also, there are through lines and trends. All of the state laws that have been passed so far really are mirror or reflect in a lot of key ways the California Consumer Privacy Act, which was the first major state comprehensive privacy law. So we'll see the same sort of trends and protections and requirements that we see in the California law are repeated in the various state laws that are passed with some tweaks. So it's still fractured. You still have to look at, at this point, there are 16 state comprehensive privacy laws. I believe there are another 15 to 20 states with legislation in some form, moving through government, whether it's been in committee or, or it's working its way through the legislature in some way. And in the past year, we've seen more states pass comprehensive privacy laws. Utah's privacy law went into effect at the end of last year. In July, just a few months from now, we'll see Texas, Florida, and Oregon, their privacy laws come into effect. And Montana has a privacy law that's going into effect in the fall. And so as the year progresses, we'll see more states enact their privacy laws. In the coming years, we predict that there will be more state laws. And the state laws that I just mentioned, are very similar to the California Consumer Privacy Act in terms of the protections that they grant consumers. They differ on thresholds of applicability, pardon me. They define what businesses are covered differently. For instance, Florida's law is really directed towards the major players. It's limited to, it only applies to companies that have $1 billion in annual revenues or more. Whereas Texas, by contrast, has no revenue threshold, although the law does state that it would exempt what are considered small businesses by the Small Business Administration, which has different definitions of small business depending on the sector and the industry. For publishers, they consider less than 1,000 employees a small business. So those entities would be exempt. So that's what we have to look forward to. more laws that are similar to California Consumer Privacy Act with their own little tweaks. They might have some additional protections. They might not have some protections that California has. So it continues to be a fractured, a fractured, landscape, on the state level.
So on the state level, what sort of actions have the states taken in the last year that might be considered seminal or kind of wake ups to small and medium-sized publishers and events companies that make up Renewed?
Well, we've seen at the state level, the California, the CFPB, the CPPA, the California Privacy Protection Agency. It's the organization, the regulatory body that enforces the California law. They've been implementing rules. I'm not sure how much of the rules implementation would affect Renewed members. They've been focusing on cybersecurity. The California Privacy Protection Agency has promulgated rules that probably won't take effect until next year because it's a very long process of notice and public comment, and it has to be endorsed by the legislature. It'll be a lengthy process, but it will focus on cybersecurity, requiring covered businesses to conduct regular cybersecurity audits and verify those, to the California Privacy Protection Agency. Again, this is only covered businesses under the California Consumer Privacy Act, so it would apply to businesses that may have more than $25 million in revenues a year or collect or sell the personal information of a certain number of California residents.
Okay. So
we've seen some other rulemaking, at the federal level. Like I mentioned earlier, we've got a hodgepodge of, state comprehensive privacy laws that really apply to entities that are collecting personal information or using personal information of residents of those states. And then we have these federal laws that apply to more limited sectors. So we've seen some action by the FTC and the Consumer Financial Protection Bureau that are directed towards financial institutions. So we'll see, probably doesn't have much of an impact on many Renewed members, except to the extent that they are consumers of financial institutions.
So that kind of is the sum of what the feds have been focusing on at this stage. They haven't really promulgated anything that we need to be aware of that, I mean, if we worried about compliance, are there things that the feds have said that make it clear what we should be doing as publishers? If not, that's good, I suppose.
No. Most of the federal laws, like I said, are directed to specific segments. So for most of the Renewed audience, the federal rulemaking and enforcement actions we've seen in the past year probably have little application. Unless many Renewed members are B2B, business to business publishers, so they don't have a lot of customers who are minors, for instance. So there's been some moves to pass regulations that further protect the personal information of minors. They've been focusing on specific industries like the financial industry or the healthcare industry. Again, I don't think that those have much application. Will have much application to Renewed members' businesses.
Okay. Have there been any enforcement or regulatory developments that would kind of illustrate what they are and aren't looking at?
Yeah, well, like I mentioned, there was, the FTC is really focusing on financial institutions. They're passing rules that require financial institutions to report a data security breach and upping the cybersecurity requirements for financial institutions that collect and hold a lot of sensitive personal financial data about consumers. the Consumer Financial Protection Bureau, which is a relatively new federal agency, has promulgated rules that govern consumers' access to financial information held by the financial companies. So we've seen the focus on federal rulemaking, at least in the last year, has been really kind of focused on the financial industry. And again, won't have much impact, I imagine, on most renewed members.
Okay. Okay, good. What about on the international front? What developments have there been with GDPR and the usual list of suspects that we have to pay attention to?
Yeah, I'll focus on the GDPR because it is really kind of the biggest and most comprehensive, privacy law. But I did want to note briefly that we've seen jurisdictions in Africa increasingly, pass comprehensive privacy laws that are modeled after the GDPR. China has made, has passed laws covering privacy. And so, if your business is international, you'll have to be continually aware of developments in jurisdictions outside of the EU. But the biggest news with the GDPR in the past year was the placement of the EU-US Privacy Shield with the Privacy Framework. Now, as a way of background, the Privacy Shield was a mechanism that was developed so that personal information could be lawfully transferred from the EU to the US. It streamlined, the transfer of personal information in a way that complied with the directives of the GDPR. It was found to be inadequate, and largely not because of anything that businesses could do, but it was largely directed, it's not considered an appropriate way to protect personal information due to the way that US intelligence agencies collect information. And so the Biden administration made some executive orders that changed the way that the US collects information, which allowed people to revise the Privacy Shield with this privacy framework. Now, what it is, it's a voluntary system. You enter into it. But once you enter into it, you're obligated to follow its directives for how personal information is handled. It sets up a framework that allows businesses to transfer personal information about EU residents from the EU to the US in a way that complies with the GDPR. And you certify that you are going to follow these requirements. And if you fail to, there's a binding arbitration procedure to enforce it once you follow it. But it's a mechanism that allows for more transfer of private information between the EU and the US. So that's probably the biggest news with the GDPR. We've seen some developments again. The rulemaking and enforcement efforts by the GDPR, I think, are interesting. I don't imagine that they'll have immediate impact on a lot of renewed members, but one thing that's occurred recently is Facebook, or Meta, the parent company, its business model of selling targeting advertising, of course, is made difficult by the GDPR. And there have been some rulings that the collection of personal information for targeting advertising, which is the business model of Facebook, is not a lawful use of private information under the GDPR unless you get the consumer's consent. So as a consequence, Meta rolled out a new business model only for European users of Instagram and Facebook, where it's a two-tiered subscription model. You can pay money, a monthly subscription fee, to use Facebook and Instagram, and you won't see any ads. Or you can consent to see ads, and you don't have to pay. It's the traditional Instagram, Facebook, social media experience for consumers. And this has, this business model has gathered a lot of attention from EU regulators. So I expect that this matter will litigated, or the equivalent of litigated in the EU. And it could, drastically affect the bottom line of these major social media companies, who are trying to find ways to make their business model work in a world where, selling personal information is a lot more, difficult. It's regulated by the GDPR. We've also seen, interesting little interaction between a previous webinar that Powley and Gibson gave on privacy. There's been some intersection between, that we gave on artificial intelligence. There's been some interaction between AI law and privacy law, and the EU has passed but not implemented a comprehensive artificial intelligence bill, which may, depending on the timeline, may be implemented this year.
Well, how does that work, Steve? What is the intersection of AI and privacy?
Well, these artificial intelligence programs, they vary quite a bit on what they do and how they're built, but almost all of them require large amounts of data to train. And many of them are trained or gather personal information about consumers. So there is where the rubber hits the road, and there's interaction between privacy laws, which regulate and govern the use of private information, and these AIs, which oftentimes are kind of developed in a black box. Other than the developers, people don't really fully understand what the training sets are, what information has been gathered, and how it's been used. And so I very much anticipate that we'll see a lot of legislative developments in the upcoming years, both in the EU and the US, addressing the privacy elements of artificial intelligence, the implications for privacy when these artificial intelligence programs are using data set, or the artificial intelligence programs themselves are processing biometric data. For instance, the Rite Aid, I believe the pharmacy chain here in the United States settled an enforcement action by the Department of Justice that related to their use of artificial intelligence programs to identify potential shoplifters in their stores. And as you can imagine, this is almost like a dystopian sci-fi story. There were a lot of issues with personal information not being protected, discriminatory application of this AI program, and various other problems that the DOJ identified. And so Rite Aid settled for, I ended up paying the fine. I don't have the number off the top of my head, but they've agreed not to use any biometric data or AI to survey its its customers for the next 5 years. I anticipate that the FTC, there has been a focus on AI that utilizes biometric information. We'll probably see more enforcement actions along those lines.
So that explains why I've not been able to fill a prescription at Rite Aid for the last year. Okay, that's good.
Right.
I would say,
yeah,
I would say that at the renewed summit in Washington next, rather in Arlington, across the river from Washington, we will not be using biometric data to decide who gets in and gets out. Steve, you and your partner, Rob Powley, will both be in attendance. So we'll be able to follow up with you on AI matters, privacy matters, and copyright matters, all your favorite topics. So look forward to that. We've often, Steve, kind of remarked that, privacy and certainly AI are moving so fast, it's almost impossible to set up rules of the road. There are some evergreen measures that people should take to establish best practices in their shops to guard against what's likely to happen. A question came up in the chat a few minutes ago, and I think as good a place to start as any. What about email marketing? Are there practices there that we should avoid, or things that have happened in the last year that would fine tune what email marketers can do?
Yeah, well, there have been developments along the lines, like on the tech end, the there has the California regulatory body that oversees the California Consumer Privacy Act has approved an opt-out procedure. It's an HTML code that can easily be incorporated into people's websites that allow consumers to choose what personal information is being collected and opt out of, non-mandatory personal information collecting. So that is something that email marketers, can utilize potentially to kind of streamline the collection of personal information, while also, respecting the rights of consumers under the California Consumer Privacy Act to, be provided notice of what information is being collected and opt out if they so choose.
So is there a real difference between consumers and people who work for businesses who are receiving, typical B2B communications from renewed companies when it comes to email marketing? I mean, are we really, as B2B deliverers of information versus B2C, treated differently by California? Do we still have to provide an opt-out option, in other words?
So it varies from state to state. Initially, California's privacy law exempted business-to-business communications, but that provision was not renewed and expired. And currently, so the exemption for business-to-business personal information collecting has expired, and B2B is B2B personal information collection and use is governed by the California Consumer Privacy Act, provided you meet the thresholds and definition of a covered business under that law, which, as I mentioned earlier, involves a certain minimal revenue threshold or the collection of a threshold amount of personal information of California residents, or a percentage of your business revenues a certain percentage of revenues of your business come from the sale of personal information. So if you fall under one of those, thresholds, then your business to business interactions and personal information collection is subject to the California Consumer Privacy Act.
Mm-hmm, mm-hmm. And how does that compare with GDPR? I mean, in some respects, I think of GDPR as being far more complete in its development, and a bit more persnickety in its application than California. And at least in our company, it's assumed that it's not an opt-out. You have to get people who are you're emailing to and corresponding with to opt in.
Yes.
And to qualify under GDPR. Is that true? And are there other ways that GDPR kind of, because of its position as kind of a global model, really should require us to pay more careful attention to it than California?
Yes, I mean, for a lot of renewed members, I imagine would not meet the thresholds required by, for the application of the California Consumer Privacy Act. However, the GDPR has no such minimum thresholds, and it applies to anybody who is collecting or using the personal data of an EU resident or someone who is within the EU, and also the UK and Switzerland, although they're not EU member states, have either equivalent laws or are governed by the GDPR. So the GDPR, as you said correctly, John, has a much broader application. And if your business is interacting with individuals that are located within the EU, then you should really take a close look about what data am I collecting and storing? What, is it coming from the EU? Then you'll have to, figure out how you process data, what you use it for, how you share it, if you do. And then you'll have to look at the notice and affirmative acceptance and opt-out procedures that are, that may be required by the GDPR for your use of that information.
Okay. So, I mean, how does that affect email marketing? Just to get down to, to the specifics, if you're, to prospective audiences, you've got a subscriber, perhaps that subscriber, he or she is covered by a license and that things can be clarified there. But if you're just trying to reach greenfield customers, what kind of protections do you need to make sure that you're applying to be sure that you're not running afoul of California or certainly GDPR concerns?
Right. So because it's a hodgepodge of laws and the GDPR is structured around a set of principles. There's multiple principles that protect the consumers, their various consumer rights. Because of this structure, really the best place to start is do a data analysis. So in my email marketing campaign, what personal information am I collecting from people? And that, under both the GDPR and the California and US state privacy laws, have a very broad definition of what constitutes personal information. It includes things that I wouldn't necessarily think are private, such as screen names that you might use on a message board that is not your real name. That is considered private information. So the first step is really to do this data analysis. What information am I collecting? Where is it coming from? What process is involved for getting this information? How am I using it? And do I share it? Do I sell it? How do I store it? How am I processing this data? Once you have the answers to these questions, then you can start looking at the application of the various laws. This is what I need to do to be compliant under GDPR. I need to set up a system where I log and keep track of consumer requests. So I may have to develop a mechanism to track and honor consumer requests to either opt out or affirmatively consent. Depending on how you're using the personal information, you'll want to develop a mechanism that allows consumers to opt out, get out, delete my personal information. And you'll want to have a mechanism to be able to facilitate that and keep track of it. And you may have to revise your privacy policies depending on how you're using the information to make sure you're compliant with the GDPR. And you'll want to train the employees that are interacting with personal information that are responsible for collecting it and storing it so that they are compliant with the GDPR. But given sort of the octopus nature of privacy laws, there's not there's not an easy one-step solution for everybody. You really have to kind of look at your specific data collection and what information you're collecting, how and where it's coming from before you can formulate a plan to keep you compliant with the laws.
In other words, it sounds as though you're saying you could argue that some businesses or some publishers would need certain types of information simply to fulfill subscriptions that other publishers, other companies would not, and that would be kind of a convincing argument before a regulator to say, well, we collect this because it's required to fulfill a website behavior that is good for the client, and that's
right. And so that, I would argue, would satisfy the lawful purpose requirement, under the GDPR, for instance, which is probably the most restrictive and comprehensive privacy law out there.
Yeah. So cookies are a monster, not to make fun of Sesame Street, but what cookie practices should we be employing to make sure we aren't running afoul inadvertently or consciously of privacy concerns?
Right. So I made a brief reference to this earlier, and I'm looking through my notes because I wanted to check. But there, and this goes to my lack of technical expertise, but the California Consumer Privacy regulatory body mentioned earlier approved a HTML system and for websites that kind of is a one-stop shop, and you've probably seen it, a similar one if you've been browsing anywhere on the internet. First time you visit a site, pops up, says what information they're collecting, and you click several buttons to opt out of all but absolutely necessary tracking, and you can select what sort of information in the cookie is collected. And so that's if you're using cookies on your website, you will need a system that presuming that you're a covered business under the privacy law. Although given the nature of privacy laws, I recommend all clients, even if they're not covered by the CCPA or the GDPR, to future-proof and come up with a policy and give notice to consumers and give them a chance to opt out, because we're just going to see more privacy laws and more expansion of this as time goes on. But people businesses that collect information about consumers through their cookies on their website, there are options out there that are compliant with the CCPA and the GDPR that gives notice to consumers and lets them select whether they want their personal information tracked or not. So it has been approved by the regulatory bodies.
Yeah, maybe you could just step back a second and clarify for me. Acceptance can either it can go one of two ways really. Works you accept and you are and if you don't give us acceptance, we will assume that you've accepted. In other words, that's the right to opt out. You've been given the chance to opt out of something, and if you don't opt out, then we've got you, and we'll use all the stuff that we can get from you. Opting in is a slightly more difficult measure. I mean, you have to get people's consent to take in the information you need. Where is opt-in and where is opt-out in play here, if you can say? I mean, is it the case that in Europe you really are talking about opting in? You can't do anything with our stuff unless we get your positive acceptance of this request, versus in the US, where it's more generally assumed that we can do whatever you want unless you opt out of this case.
Right. I mean, that general assessment, and it's hard to apply generalities without diving into the weeds too much, but I'll try to avoid that. You're generally correct that under all of the US privacy laws, they're providing an opportunity to opt out from the sale of your personal information or the sharing of your personal information is the extent of the law's protections. It's an opt-out for limited purposes generally. Now, the GDPR is much broader, and there are some uses of personal information, some collection of personal information under the GDPR that requires more affirmative assent. But that is something that businesses would have to deal with after they do the data analysis and they figure out where all their information is coming from and what they're using it for. Then you can determine whether providing the chance to opt out is all that's required, or if there needs to be some more affirmative acceptance by the end user.
Yeah. Okay. So Are there other evergreen practices that you would recommend that we do? As we pummel Steve with questions, I also want to hold out the opportunity for folks in the audience to share their own experiences, because in some respects, when we talk about evergreen practices and defenses, this is pretty burdensome. It's certainly a lot more burdensome than when I got out of journalism school and joined the media business. And in a way, you'd like to think, well, if it's overly burdensome, it can't possibly relate to me, but I'm not sure the law is that kind. So we do have to be kind of proactive and kind of do things to make sure that we don't fall into jeopardy by not being in compliance. And our businesses, Steve, run across, as you know, not just publications, but also events where people are showing up at conferences and the need to gather information there. And indeed, the tradition of sharing information, what we call business card information, is just an historic practice. You exchange the business card. That's called networking. But nowadays, you can't even be sure that exchanging business card type information is not something that's requires affirmative acceptance in under some.
Well, you can always opt out by not handing your business card over.
Exactly.
I think exchanging business cards is a safe practice so long as you're not collecting that information and selling it. In those instances, if I was collecting business cards, I got it reviewed and creating a database and then selling that, then yeah, I would be most likely implicating certain privacy laws. But I think for the general networking practices you described, your use of the personal information is not such that privacy law would necessarily be implicated.
Yeah, well, let's take it one step further. I mean, one of the things you want to do as an event company or a publisher, for that matter, but we at Renew often are one at the same time doing both. You're gathering that information to collect it so that you can inform people of other products, other things you're doing, other events that you're doing. Is that, does that require acceptance, or are there any special considerations we need to give to that? Someone shows up in an event and they certainly don't give their medical records, they don't give the names of their children, but they do give their email address, their phone number, to the extent that anybody uses the phone any longer. Maybe other forms of communication that social media allow. Some information about what their business is and what they do at their business, all part of quote unquote business cards. And that's collected, collated, and made part of marketing practices down the road. And at our company, GDPR came along and there was an immediate freeze on that for fear that was somehow not acceptable. Is that too cautious?
Well, as a lawyer, it's hard to be too cautious. We generally, counsel caution and are risk averse, as a class. But it's not a bad idea. It was not a bad, totally freezing the process, maybe one thing, but it's not a bad idea to take a look at it. Yeah, and in terms of collecting personal information for marketing, that absolutely can fall under the ambit of the GDPR. But as long as you can use that information in a way that's compliant, giving the people you receive your marketing emails an unsubscribe option, right? A chance to opt out. Have a mechanism so that people who gave you the business card can contact you later and say, hey, take me off this list and delete my information. Mm-hmm. As you can relatively easily implement mechanisms that allow you to be compliant with the GDPR and state privacy laws for these practices. But it absolutely was not overly cautious to take a look at every aspect of your business where you're collecting any sort of personal information, names, phone numbers, email addresses, all count as personally identifying information. And it was absolutely the right move to, hey, let's take a second look at this and make sure that we're compliant.
What about the right to be forgotten? People can call up later and say, yeah, I'm going to opt out where I opted in before. Okay, I understand that. But you have some fellow who's in some part of the world contacting you and saying, look, not only do I want to be taken off this, but I want you to wipe out all data related to my experience on your website that you might have. Are those practices things that you need to be aware of in the States? Is there some sort of kind of a statute of limitation or statute of limits to how long you can hold data without asking people if it can be continued to be held? In other words, your right is to keep it for 3 years. If you after 3 years you got to expunge it, if you haven't otherwise asked somebody to reaffirm their acceptance of your retaining this data. Are there any rules like that out there that we need to be concerned with?
So yeah, generally speaking, there's a right to be forgotten that is enshrined in the GDPR. It's enshrined in the California Consumer Privacy Act and various state privacy laws that follow the CCPA. And the contours of the obligations of these rules kind of vary, but there are many exceptions to the rules. So if there is an issue with feasibility of deleting the data and potentially burden, it's likely that there's certainly with feasibility that it may fall under one of the various exceptions to the right to be forgotten.
Okay, and that and the right to be forgotten and is one thing. What about retention? Are there any standards of retention that we need to be mindful of and to keep ourselves from slipping afoul of privacy rules? Or are we able to keep records on our clients for as long as we like, even if they've stopped being clients for years?
Generally speaking, there aren't timeline restrictions under the U.S. privacy laws. There may be under the GDPR, and so that's something that as you're doing your data privacy your data analysis, and you're looking at what how long you're keeping the information is also something comprehensive, and you can, along with counsel, determine whether under your company's specific legal obligations, which umbrellas you fall under, whether you need to look at deleting information after a certain period of time. But generally speaking, at least with the US laws, there's no such requirement.
Okay.
Other than when consumers opt out.
Okay. All right, good. We've got a couple more minutes before we have to wrap up. Are there any other questions that people want to put into chat or raise their hand and ask bravely directly to Steve? Okay, good.
I have a follow-up to an earlier question. If we didn't, I can't see the chat, so, but I was asked about email marketing. And one of the developments in email marketing that I had thought of but moved on before I could mention it was, and this may be of very much interest to some to renewed members, is if anybody who is familiar with email marketing is probably aware of invisible pixels. This is how we can track whether emails are opened, measure engagement, see if people are opening and reading the content that we send them. There's been some litigation regarding the privacy implications of sort of email pixel tracking. And there hasn't been any like strong developments or any solid developments. It's very early in the process. Some of these complaints were dismissed at the motion to dismiss stage, meaning that they failed to allege enough factual information to make like, to make a claim for a violation of a civil law. But some have survived that. And as these cases move through the courts and we get rulings, it may implicate the use of tracking technology. And if you use email tracking, you may have to look at a more robust notification system, a more robust option, providing more robust options for people to opt out of visible pixel tracking. But those developments are going to be slow coming because things will have to work their way through the courts.
There's an awful lot of data that you can collect, and those little pixels are kind of common practice for most email campaigns. And arguably it's how people improve their products, how they improve their outreach. And it would be sad to see the use of them be thwarted by privacy laws. On the other hand, notification is probably your best friend. Just being out, being clear with people in your licenses that's what you do. It's hard to argue that you haven't been notified if a license makes clear that those things are there.
I agree with that.
I mean, the question being, are good licenses protections, or do you still need to do things beyond what you might beyond stating these things in a license?
Most likely, if I had to predict how these litigations are going to unfold, as you noted, pixel tracking is pervasive throughout the marketing and email practices. And so I don't see them disappearing. I don't see that practice being outlawed. The collection of personal data and tracking of personal data to show you targeted ads is also pervasive. That hasn't gone away. And as you suggested, John, the solution is going to be if these practices fall under more scrutiny, the practice is going to be notification. If you're a publisher and you track emails that you send your publications to clients, yes, absolutely. In the subscription agreement, notice and consent that we may use invisible pixels to track your email. Just clarity with the consumer, notice and consent, and most likely, you're going to be okay under the law if you have good practices. For email marketing, we're emailing people that you may not have an established business relationship. We'll see what sort of notice requirements develop as a result of these litigations. What courts find the laws require specifically for the use of pixel marketing.
When you mentioned notifying, and another sort of notification comes to my mind. We haven't, except very, very remotely, tangentially touched on it. Cybersecurity and responses to cyber breaches. My sense is the GDPR is far clearer in describing what people must do in response to a breach than U.S. law or U.S. state laws are. Is that fair? I mean, there's a real speed component to acting following a breach and making regulators and consumers know that you have been breached. Their data may have been given up in a breach to characters who were messing around in your systems without authority. Is that the case? Is Europe much more much clearer on responsibilities in cybersecurity breaches than than the US, or is the US caught up in the last year?
I would say that's a fair assessment, but we've definitely seen developments in cybersecurity on the US end. I mentioned earlier, I mean, the Europe is more advanced in terms of, cybersecurity regulations, like notifying the regulators when there's a breach. The FTC has only just promulgated a rule requiring financial institutions to report to the FTC data breaches. We're definitely seeing more of that. There's cybersecurity requirements under US state laws. And like, as I mentioned, the federal laws that deal specifically with certain segments have been, there's been a focus on cybersecurity. But in the US, because there are multiple parties that have jurisdiction over cybersecurity incidents, it can be a lot less clear and developed than under the GDPR. But we've seen state attorney generals move, take enforcement actions against companies that have, either have negligent cybersecurity protections, suffer a breach, and so we've seen state attorney generals go after these companies. We've seen federal agencies, like I mentioned, the FTC, go after these agencies. And in certain circumstances, if the breach is bad enough, we've seen law enforcement agencies get involved on the U.S. Investigating these breaches.
But there are no laws that we know of. No. There may be some obscure places, but no that kind of mandate that in the U.S. you must reply to, or rather respond to regulators within, say, 72 hours, as there are in Europe, to notify them of a breach.
Well, the state laws that are modeled after California do have cybersecurity requirements, but there's nothing like reporting. You must report the breach to the regulator within 72 hours or whatever the case may be under the GDPR.
Okay, good. Well, Steve, we've covered a lot of ground. Is there anything you'd want to say in wrapping up to our audience? All of whom wish you well over the next couple of weeks and can't wait to see you in Arlington at the summit.
I'm looking when we spoke, and I'm asked to do a privacy update. It's fun. I love following privacy laws, but because of the various hodgepodge nature, the differences in collection practices and use of personal information amongst companies, it's very difficult to have sort of a general webinar. This is what you need to do. So I go back to my evergreen advice. Just be cognizant of what information you're collecting. Know what information you're collecting and how you're using it. That's the first step, and then you can develop a plan for complying with the various laws. And ultimately, as burdensome as some of these laws can be, I really think it's to the public benefit, to have transparency about, how your personal information is being used as a consumer, and being able to, delete it and be forgotten. And so it's difficult to, provide kind of general advice that applies to everybody. Aside from just be cognizant of what personal information you're gathering and how you're using it, so that you're able to formulate a plan so that you can comply with the law. Yeah, well, as my mother always told me, transparency is a good thing. If you can't be transparent, Johnny, that means you must have done something wrong. So I think that's maybe where I'm going to end this. And Steve, thank you very, very much for joining us for the last hour. As I say, you've covered a lot of ground. As renewed members, you are welcome to contact Powley Gibson about copyright issues, about trademark issues, and certainly about privacy issues and general concerns about AI.
all of that, Steve and Rob Powley and their partners be happy to help you with. And Rob and Steve both will be down in Arlington, as they say, in June for the summit. So you'll be able to meet them there. And I was going to say, and they'll buy you all a beer, but that's probably not what you had in mind, Steve, right? You want sober conversations with people. So,
Yes.
well,
So sober attorneys. We're sober and professional.
Sober-minded attorneys. Anyway,
Yeah, no, thank you, John. Yeah, Rob and I are both looking forward to the renewed summit. I attended 2 years ago, but due to conflicts was not able, unfortunately, to go last year. So I'm definitely looking forward. It's a great group of folks. And I had a great time with my partner Tom 2 years ago at the summit. So very much looking forward to it.
Well, Rob told me he's so much looking forward to it. He actually had a court calendar change so he could go up. It means that much to him. So anyway, thanks, Renewed members, for joining us. This is recorded, so you can refer back to it on the Renewed website. And if you've got further questions, by all means, contact me. If you can't find Steve Ankrom, I'll make sure I can.
Should have my contact. Yes. I'm reachable by phone, email, smoke signal, Telegram.
Excellent. All right. Thanks, folks. Take care.